Thank you, everybody, so much for being here with us today. I am Michelle Morris from Consolidated Planning Group. We've got some great information for you today. This webinar is going to be presented mostly by attorney Mike Day and special needs divorce coach, Ann Hughes. We're going to be talking about children with special needs and divorce and the things that you need to keep in mind if you are going through a divorce situation in your life. So first of all, before I turn things over to them, I want to let you know that we're in webinar mode, which means that we cannot see or hear the participants. But we do want to know if you have questions or comments. So please just put anything that you want to say into the chat box. I will be monitoring that, and I'm going to let the speakers know as questions come into the chat box if they are, if the question is related to what they're talking about right then. And then if not, we might hold the question to the end. But either way, we're going to get to as many of your questions today as we possibly can. The other thing I do want to let you know is that we record all of our webinars and we put them on our YouTube channel. So later on today, you will receive an email with a link to that recording. You're also going to get the slides from the presentation today. So whatever email address that you used to register for this webinar, you can check that later on today for those links and the slides. Consolidated Planning Group, a little bit about us. We present these webinars 2 or 3 times a week. We are financial advisors first and foremost, but we focus on serving families where there's an individual with any kind of developmental or intellectual difference. We've been doing this for over 30 years. We are members of the Special Needs Planning Academy. We are nationally certified as Social Security advisors, and we're chartered special needs consultants. So basically, anything that any traditional financial advisor would do for you, we can. But we do it through the lens of understanding all of the nuanced information and rules and regulations that surround the special needs side of planning. We are located just outside of Houston, Texas, but we work all across the United States. So anybody that you know who is anywhere in the United States who might benefit from this information, I hope that you'll go ahead and share it with them. Families come to us when you're thinking about special needs planning. Families come to us for things like protection plans, helping them protect their family in case the main caregiver or the main breadwinner or both happen to pass away or become disabled. We do a lot of lifetime care planning for your loved ones, transition planning. We can help with ABLE accounts and special needs trusts and understanding, what buckets of money you need and how to make sure you don't jeopardize any of your benefits. And of course, we're here to educate you and to advocate for you. There are over 263,000 financial advisors in the United States, but out of those, fewer than 200 financial advising firms truly focus on special needs planning. So it might seem difficult for you to find an expert in the field because it's 0.1%, less than 0.1% of all the financial advisors who truly get this. But when you're here with Consolidated Planning Group, you are in the right place. A couple of little pieces of information before I turn everything over. We know that it keeps you up at night worrying and thinking about who is going to care for your loved one when you can't do it anymore. And to that we say, first of all, it's important that you start planning as early as you can. If you have a longer runway, that gives you a chance to make smaller tweaks and changes to your plan as you go along and have a bigger impact. Definitely, we want you to think about what is going to happen after high school. There are fantastic resources out there for jobs, for education, for housing, and you might want to check those out early. Look at those programs, decide what is right for your family, who are them, and see, if they have a wait list that you need to get on. And then finally, just be really careful when you're thinking about the future and you think, oh, it's just easy, I'm going to let a sibling step in as caregiver. It's not always as easy as it sounds. And someone who might not understand how hard it is to be a caregiver might jump at that opportunity and be willing and say they want to help, but that willingness might turn into a feeling of obligation later on. And from the other perspective, think of your person who has a difference. Here's their sibling who has been their best friend and their partner in crime. And now all of a sudden that person is stepping into a role that might feel a little bit more authoritarian. And that could create some resentment too. So just be careful in those situations. We're going to talk more a little bit about what's consolidated planning group can help you with in special needs planning. But I know you're here to see Marianne and Mike. You're not here to see me today. So I'm going to turn this over to them so that they can dig in, introduce themselves, and talk to us a little bit about divorce. Okay. So I will let you guys take over.
Thank you so much, Michelle, for the kind introduction. Pleasure to be here again. So, for those who don't know me, I'm deeply committed to this work because of my personal and professional interest here. I am the mom of two young adults now on the autism spectrum. And several years ago, I had to go through divorce and trying to figure out what I had to do to figure out how to advocate for my kids, but also how to get through the process, navigate it, and figure out how to focus on the future. And so I did get a great result, but as a result, I didn't want other people to have to go through the same thing I did. So I created Special Family Transitions, and I'm now a certified special needs divorce coach. So primarily, I work with one parent as they're trying to navigate their way and figure out how to help their kids in the process. But I've also taken other trainings where I can maybe work with both parents, have a different perspective, more holistic approach as a co parenting specialist, pre-mediation divorce coach to get you ready for those important discussions you're going to have as part of your divorce process and ongoing. Hopefully not too much ongoing, but definitely the negotiations never end as a parent and trying to advocate for your child. I'm also a co-director of the National Association of Divorce Professionals or Special Needs chapter. So I get to meet and learn from and share information with other professionals who are committed to this field and love sharing information in different ways. So just want to sure I've done several different podcasts with webinars with Consolidate and other ones you can find on my information. So Mike, turn it over to you.
Thank you, Marianne, and thank you, Consolidated Planning, Michelle, and Allison Skalberg, for inviting me to speak today. I've had the privilege of doing several of these presentations over the years, and I always really enjoy it. So a little bit about myself. My name's Mike Day. I'm board certified in family law. I practice primarily in the Houston area, and my concentration is on all things family law. Most of the time that means divorce, but sometimes that means that people have already been divorced and they're having to litigate things after the divorce. Sometimes that means that people were never married, but they had a child together. And so either way, I love this work so much. I especially love working with families with children with special needs. It has a special place in my heart. I've done a lot of these cases in my career. Um, and the one thing I'll say is that not every lawyer has done a lot of these cases. And so my big goal for today's presentation for the audience members is for everyone to come away with a little bit more information than maybe they had before. Maybe feeling a little bit more empowered than they did before we started. And this is a very challenging process. I mean, divorce in particular is one of the most challenging things people go through in life, even if it's quote unquote amicable. And so, one of the things that I think people need to know before they get kind of given all this substantive information is just show yourself a little bit of grace and don't just do it once. You're going to have to do it a lot, and that's
Yeah.
okay. That is absolutely okay. And if you come away from this presentation feeling a little bit less anxious, then mission accomplished. So.
Right, right. And like Michelle said, these are the kind of things that keep us up at night. What's going to happen to my child in the future, given that their needs are lifelong? This is not a typical divorce or situation where their needs are going to end at 18 and we don't have to think about it after that. This is kind of a life care plan where we have to look at everything they're going to need now and in the future. Granted, we don't have a crystal ball. We don't know exactly what that might look like, but we have to hope for the best, but plan for the worst scenarios sometimes in this process. And so the good news is that in Texas, child support can be lifelong. And Michael talked more about that and how that works. And it's important to have things set up properly, like people like Mike and Consolidated Planning Group, to understand how things need to be worded and done as part of the process to be able to protect your government benefits that you may be either receiving now or maintain eligibility to receive in the future. And so given the intellectual and emotional and different type of disabilities that we have for our children, it may be harder for them to understand the transitions, what's happening to the family. And so there's ways to help them through that and help the family focus on the future and how to then co-parent effectively together. And then as caregiver versus breadwinner, we may look at things in a different way, but we want to try to understand the other's perspective so that we can come to resolution and figure out really what's best for the child and how can both parties come to agreement together based on what the child needs. And then given the parenting plan and how that's going to look in each home, that's something that needs to be considered based on those different circumstances and where the child is and what would work for them, as well as what's going to work for the parent schedule too.
Yeah, I mean, the one thing that I would like to add to that point is that what really, every divorce is unique in its own way, right? But one of the things that really separates divorces involving children with special needs is that you need an interdisciplinary team. Like you have to have it.
Yeah.
It is mission critical. And if going back to having a little bit less anxiety, let me tell you another big an insight that you need to walk away from today's presentation with. And we're giving you questions to ask prospective professionals who might be helping you in this space, okay? And I will tell you that the first question that you ask somebody, let's say you're going into a consultation with a divorce attorney, and you say, "Well, can you write the special needs trust for me as well? Can you draft that?" And they say, "Yeah, I can do it all." Don't walk away from that person's office, run. Because that's like saying, I'm an anesthesiologist and a surgeon. I can put you under and I'll operate on you. No, no, no.
Right.
And in fact, Houston's a pretty big city, right? And there are lots of really great estate planning lawyers out there. But there really aren't that many great estate planning lawyers who work in the very specialized area of special needs. There just aren't that many. Off the top of my head, I could probably count roughly on two hands how many lawyers in as big of a place as Houston. When I say Houston, I'm including Fort Bend County, I'm including Montgomery County, I'm including far Northwest Harris County. I'm not just talking about lawyers who office in the Galleria or Greenway or anything like that or downtown. I'm talking about the whole, expanded metropolitan area. There just aren't that many lawyers that I would trust in this space. And so, the other thing that I would suggest to you is that you do need a financial planner that understands special needs issues. And you need a financial planner for two reasons. One, they can help you answer questions that somebody like Marianne or myself, we're not really there to answer those questions, right? Like, I'm not there to tell you how expensive the life care plan for your child might be, right? Not my job. And you don't want me doing that, right? It's like you don't want your anesthesiologist operating on your neck. They're just very different disciplines. Um, and uh, and so, but you need an estate planning lawyer who understands special needs trust because they kind of figure out what the goals need to be, especially when you're talking about preserving eligibility for governmental benefits. And then it's the lawyer's job and the other supporting professionals to work backwards from that. So let me give you an example. Sometimes, especially in more of the gray divorce, right, when people are getting a divorce later in life, sometimes there are issues with Medicare. If someone's going to be eligible for Medicare and claim Medicare before their child with special needs might be able to have some benefits along those ways. Well, um, you uh, you just need to be mindful of that, right? And that's a great example of working backwards from that. The other thing, the other big takeaway is that some of these questions don't have certain answers. There are a lot of areas of the law that have uncertainty, and that's especially true on family law matters involving special needs. So much so that a few years ago, there was a case that went up on appeal. You had an adult disabled child who had gone to college and was in graduate school, but had a physical disability. And the mother um, was the caregiver, and there was still child support in place for that child, even though that child was getting a graduate degree. And it went up to the Texas Supreme Court because the dad was like, "Oh, my kid's in grad school. Why do I have to pay child support?" And one of the two former family court judges who have served on the Texas Supreme Court in the last 20 years, because the Texas Supreme Court didn't take the case, she said, "We didn't take this case, but man, we need to take one of these cases one of these days, right? Because there are so many unresolved issues about the child support statute in particular." So, um, yeah, let's go to the next slide, Michelle, please. Okay. All right. So, let's talk about, and I said we have a question, and we can kind of address that in a little bit. Preparation for the divorce. Mary Ann, would you like to start with this?
Sure. So I can come in as a coach at any point in the process, but ideally, if you're thinking about getting divorced, this is the best time to seek out the support of someone to get you started on the right track and in the right mindset. So, divorce, as we talked about, can be so overwhelming and there's so much going on, but we have to think about it strategically. It's really not a time or place for emotional justice or try to do what you think it needs to happen. It may or may not work that way. You need to think of this as a business and legal and financial transaction, and how to approach that in such a way where then you can share the information and try to get the results that benefit you and your child, um, and and then meets the needs across the board for the other side as well, as much as uh, to try to come to some sort of agreement to make that happen. Most divorces end up in mediation and some sort of agreement. There's a small percentage that will go to trial in a litigated manner where the judge has to make a decision. But really, do you want a stranger making life decisions for you? It's better for you to be involved in the process and try to come up with an agreement, either through your lawyers, with your soon-to-be ex-spouse, or whatever it is, so that it's something that you know that you can live with. And the ideal situation, as they say, is when no parties are 100% happy, right? There's going to be some give and take. But how do we get to the point where we're ready to understand what we need, what our vision is for the future, and make plans to get there? So divorce itself can be overwhelming. And so I help people kind of take it one step at a time to get through that kind of project plan, as I like to look at it. So you would have to figure out who you're going to work with, the team you're going to assemble. As we talked about, there's a family law attorney, a coach, financial, as well as perhaps mental health professionals, estate planning attorney. So it is, as we mentioned, multidisciplinary, because there's so many things to think about that maybe you don't need to think about in another type of divorce, about planning for the future and for the well-being of your child.
Yeah, there's one point that I want to really touch upon, and that is with what Mary Ann just said. And she said, "Well, it's a business decision," and there's a lot of truth to that. But it would be unrealistic, I think, to expect people on day one or leading up to day one to. It's one thing to know that it's a business decision, and it's another thing to feel it, to really internalize it, right? And you're probably not there, right? Generally speaking, right? And so then the question is, well, how do I get there, right? Like, how do I really prepare for myself for this? And while I'm not a mental health professional, I've spent a lot of my free time studying trauma. I've read about it. I've done a lot of CLE presentations about it. A couple years ago, I moderated the annual ethics panel for the Houston Bar Association and had one of the panelists was a woman by the name of Molly Gordon, who's a professor of psychiatry at Baylor College of Medicine, and she was actually the lead plaintiff's expert in the Epstein trafficking cases. And it was a really interesting presentation because trauma is it's an insidious thing, and it doesn't have to be something as bad as you were trafficked by Jeffrey Epstein, right? I mean, you can have betrayal trauma from an affair. You can have betrayal trauma from something else, like a gambling debt that the other spouse had, that he or she hid from you. You see it a lot in alcoholism, right? You see it a lot when someone is married to an alcoholic, invariably, there's going to be some betrayal trauma there. And, a lot of times you will see things like personality disorders, right? I mean, it's become part of the zeitgeist, but that's not happenstance, I don't believe. And so then the question is, well, that's great, Mike. Okay, I'm not going to be there day one making a business decision. Well, how do I get there emotionally or psychologically? And that is to suit up with emotional armor. And the way to do that is through insight. Okay. And so start educating if you think your spouse might be a narcissist, go on Dr. Romney videos. I'm blanking on the gentleman's name. There's also Dr. Romney's out of Los Angeles. There's a gentleman out of Texas, and they're on YouTube videos. Just watch them. Be very insightful. If you and if you have a situation where you're worried about it becoming high conflict, right? Especially if one spouse is very controlling. I know sometimes we talk a lot about in these presentations sort of from the female perspective, but I will say that there is sort of this a sort of mating that I've noticed in my career where you'll have these really nice guys that gravitate towards women with borderline or bipolar propensities. And how do you prepare for that situation? Um, there's a great book called When Divorce Fails by a gentleman named Arthur Leonoff, and in my opinion, he provides the best how-to on how to avoid having a high conflict divorce. And his fundamental theory is that people go through life and they have some sort of challenge and adversity. Maybe a parent was abusive, maybe they moved a lot, maybe there was a parent that abused substances, whatever the case may be. And then you go through life after that challenge, and then you meet somebody. And then whether it's consciously or subconsciously, there's a part of you that gravitates towards that person because it's going to help you get through whatever your earlier challenge was. But when the wheels fall off the marriage, you have sort of the sort of collateral damage from the initial challenge, and it dovetails with what you thought was helping you through that, or maybe you weren't even aware that you had made that decision, and they come together. And it's almost like you're driven by these blind or subconscious impulses. And the way you do that, it's he coins the term pathological disillusionment. And so when you're preparing, I would say the biggest thing is emotional preparation. Um, and then the second thing is do what you can to get information beforehand, especially if you're one of the spouses that were not privy to the finances. What does that really mean? Well, you can go to the IRS and get your own copy of your own tax returns. There's a way to do that. If you have a financial planner already, just talk to the financial planner. Just say, I want to talk, right? If they're, and I've seen this happen with college applications, right? A lot of times there's a FAFSA application. use the FAFSA as a springboard to get information. Okay. It's, and then some things are more complicated, right? I mean, I come from a family of Exxon lifers, so I'm not picking on engineers, but if you're married to an engineer and they work for a big company, the good news is there's going to be some emotional challenges with that. But 401k, that's pretty simple, right? But if you got somebody that owns their own business, well, that actually is more complicated. And you're just going to have to be resigned to the fact that you're not going to be able to get all this information before you file, right? If you're one of those people that's like, I got to know everything and then know how it's going to unfold, I'm very sorry. That's not going to happen. That's not how family court works. At least not in Texas. And so that leads us to phase two, the filing phase, the temporary orders phase. Filing is critical. Physical safety is the most important thing. Most important. Temporary orders, to Mary Ann's point, most cases subtle, right? Most cases subtle. But you would be a fool if you went in to a consultation with a lawyer and you asked that lawyer, are temporary orders a big deal? And that lawyer said no. And you're like, okay, great. How do I get you paid so we can start this process? Because temporary orders are effectively a trial that you have to get ready for, right? Now, sometimes people can agree amongst themselves, right? And that's great. But even the cases that ultimately settle at mediation, and you don't need to uncover every rock and do a bunch of discovery that doesn't necessarily add value, right? I mean, but again, like, don't just go into a custody hearing on temporary orders thinking, well, I've always been the one taking care of the children, so I'm going to get that automatically, right? Uh, I, I would think that that would be a mistake. And I'll just leave it at that. And we kind of have a case study here, and we've kind of gone into the first two phases. But let's talk about phase three, coming to resolution. Mary Ann?
Sure. So I was going to say, in temporary orders and mediation, and then your discussions with your team, be sure that you're comfortable to what's being proposed and what you're agreeing to. Some people feel like, oh, it's too much work, it's too much stress, I'll deal with it later. But really, know what it is you want and what you're willing to accept and not accept. Because once you have temporary orders, sometimes it may be hard to get that change and go a different direction later. So be sure whatever you agree to, whatever you share that's important to you as part of the preparation phase, and as you carry that throughout your divorce and the tone that it's going to take, make sure that you're comfortable with what you're agreeing to. Some people think they just want to get this over with and done with, but this is your opportunity to stand up for what's right. Granted, you may have to be flexible in some areas, but definitely don't give up what's really important to you and driving you in this process of coming to resolution. So look at how is it going to impact you? How is it going to impact your kids and life afterwards?
Yeah, I would say that's absolutely correct. The one thing I will say is, um, don't be afraid to send your lawyers emails. Some lawyers don't like to answer substantive emails from their clients. Could be any number of reasons for that. But, when you're interviewing lawyers, ask them, well, can I just send you substantive emails, right? And you just answer them in like 48 to 72 hours. I mean, don't expect a 24-hour turnaround every time, right? Because especially with the better lawyers that try that who get the harder cases, and so maybe they have more than 10% of their cases go to trial, right? I know that I'm dealing with that situation right now. And but the so I would say just that would be a good screening mechanism for when you're interviewing professionals to ask that. Yeah. And the other thing too is, uh, and this comes back to Marianne's point about revisiting temporary orders. Even before you get to the temporary orders phase, there's something called interim orders sometimes, or a band-aid order. And they're like, well, just put a band-aid on the situation and we'll go back to court. But I recently took over a case where I was not the lawyer that negotiated the so-called Band-Aid agreement. And it's become problematic. I mean, we're going to get the case to a jury trial within 9 months of filing. So, but and I feel bad for the client. I do, because it's not an ideal situation and it's not in the child's best interest. But, um, just be careful of Band-Aid orders. And don't enter into them lightly. And if a lawyer says it's just a Band-Aid order, well, you know. If your spidey sense is telling you something, listen to your spidey sense. And then phase 4, post-divorce. So I tell people, look, we're going to go to mediation. Lord willing, we're going to get the case settled, right? That's not the end of the football game, though. That's the end of the third quarter. There's still the fourth quarter. And what is the fourth quarter? The fourth quarter is the drafting of documents, and it's really coming to grips with different roles, right? Because to go back, there was an earlier slide. Were you the breadwinner? Were you the caregiver? Maybe a little bit of both for couples where both parents work. But the one thing that I will say that I've really noticed with people who had clearly divided uh, domestic divisions of labor, right? So, is that the parent that was primarily hands off on the caregiving, all of a sudden they want to be more involved, right? And invariably, the client that was normally in charge of the kids is like, well, I've done a great job so far. What's the problem now? And like going through divorce, it's kind of like going off to college after high school, and you're sort of you're redefining your identity, and you're differentiating your single self or your divorced self from your married self. And so that parent that wasn't hands-on with the kids, they're gonna get more involved. Now, sometimes that's not well-intentioned. I mean, let's be honest. But the flip side is that you got the caregiver and all of a sudden they want the P&L statements for the breadwinner small business. And the person's like, what? That person doesn't trust me. I'll put food on the table all these years. And it's curious because you're getting a divorce because for whatever reason the marriage didn't work out, but you're now put in a position where you're having to be, I don't want to say empathetic towards your ex-spouse, but like, going back to the notion of insight provides emotional armor. I mean, insight makes you a better litigant, right? Like it just does. You want your best day at the courthouse, whether it be through trial or settlement, show up outside in real life as the best version of yourself, right? It's not a few good men. There's not one person 9 times out of 10 that's going to come away as the definitive winner. Judges love to tell both sides no a little bit and both sides yes a little bit. It's very rare that you will get someone just completely hammered by a judge. So just be mindful of that. And going back to uh, all 4 phases, right? I mean, this is a grieving process. It's a lot of times it's informed by trauma. And when you do have a lot of trauma and someone, you know, it's uncomfortable as the lawyer because on one hand, you have to get people to make a decision, right? Because the legal system, for all of its nuances, it's a pretty simple decision tree, right? The case either settles, it goes to trial, or somebody gives up. Those are the only 3 possibilities that can happen, right? But to get there, it's hard. Your brain is not functioning the way it should. Your cognition, your sense of discernment. Maybe you focus on things that don't really matter. Like if you have a lawyer that's telling you that the judge is going to care a lot about adultery, I will say historically that was not so true. Now there actually are some judges, both in Harris County and outside of Harris County, that do care, right? So I can't tell you blanket, I mean, if there's a certain judge in Brazoria County who hammers people on adultery, right? That's just what he does. Um, I had a case that I tried years ago in front of the one of the Democrats who got elected in 2018, and lo and behold, she does not care for adultery either, even if both sides do it. She punished one person for it to a certain extent. Um, but just, it's a process. I mean, and it's such a cliche thing to say, but it really is, and you're going to have to give yourself grace as we go through it. Michelle, can we go through the next slide? All right. Yeah.
Yeah, we've kind of
We've touched through a lot of this stuff. Yeah.
gone through a lot of this stuff.
Yeah.
I was wondering if you're gonna do the I want to hear these case studies.
Yeah, the point of those is that depending on the tone and situation of your divorce is maybe how you're going to handle it. But there are ways, as Mike mentioned, to know how to deal with a spouse or soon to be ex-spouse, or if you're already divorced, who has maybe certain ways of looking at the world. And so, as a divorce coach, I help people get from the emotion side to the business side of divorce. But part of that is knowing how to communicate with your team, how to communicate with your ex-spouse, how to communicate, share information with your kids. So it's all relevant, because you can make a high conflict situation even more conflict, but then there's also ways to bring it down. And that's the goal, is how do we find professionals, whether it's lawyers, who are going to not make things worse, but help us get to a resolution. And part of the post divorce is not then to be stuck in a life after divorce where all we think about is divorce and what happened and how things aren't fair or right. But we want to then reinvent ourselves, find new purpose, take what we have. You can always go back and modify later if there's some legal issue or monetary issue. But how do we then have a life beyond divorce? And I think that's important too, to think about, because this is the divorce process does have an end, right? You're going to eventually have a decree, but then whatever happens after that and how you carry yourself and how you raise your kids is so important. And that's kind of what kind of leads to this slide, is how do we support our kids through the process, whether it's early on as the news of divorce is just arising, or whether it's something that's an ongoing co-parenting issue. And so the important thing is we want to understand where our child is. And just because they're a certain age, especially the population that we work with, they may be more like a 3-year-old as opposed to like a 15-year-old, right? And so we have to look at their where they are and how they process information, but how do we share that information? And so we don't want to ever just throw them all of a sudden into a whole new role without preparing them. So in the past, for my family, I've used social stories when we were going to have a new experience or go on vacations. And I took a similar approach for divorce when I had to explain what was happening to our family and what they could expect to lower their anxiety and what they needed to understand to feel comfortable and safe, and that they're going to be loved by both parents, but now it's going to be in different homes. Having a visual calendar and visual aids is also helpful for not just at school, but also at home. So to know where they're going to be when, so that once again, the anxiety level goes down. One of my sons every day asks me multiple times a day, what are we doing today? What are we doing tomorrow? And the next week, and planning ahead. And so to have that on paper in a form that he can understand helps a lot to calm him and to know that everything's going to be okay. You're going to spend time with mom and dad, and here is how that's going to happen. And just because our kids aren't verbal, some of them, doesn't mean they don't understand what's being said in front of them, whether it's a conversation with the ex-spouse or whether it's a conversation with the lawyers or with your family members or neighbor. We don't ever want to speak negatively about the other parent, because the child sees themselves as half mom and half dad. And if they see one parent hear something bad about them, they might personalize that and internalize it and feel like maybe they did something wrong. So we always want to make sure that they know it's never their fault, and that they're going to be taken care of through this process and afterwards. And also there's resources to help them cope. We talked about mental health professionals. They're very important in the process for the adults, but also for the kids. There are ones who have experience working with children with different abilities. And so we want to try to seek out those resources as well. And it's granted, it may be hard for some maybe who aren't able to be in a counseling type environment, but there are ones, whether it's play therapists or certain ones, that they can try to support them the best way they can.
Yeah. I think Marianne's spot on with everything she just said. The one thing I will add is there's a method of communication called BIF, brief, informative, friendly, and firm, and that is how you communicate when you are co-parenting with somebody. Okay, I know I gave you some feedback about if you ask a lawyer a certain question, they give you an answer, and maybe that's your cue to leave the conference room when you can. I'm going to give you some advice about a divorce, selecting a divorce coach. You know, people, especially in higher conflict situations, sometimes people are told, well, you know, what you need to do is you need to respond back to them and be like, you know, your attempt to mischaracterize who I am is duly noted or something like that. Don't do that. Judges hate that. You're not going to win friends and influence people by acting like that. You just do the Biff approach that was pioneered by Bill Eddy. You know, you put your kids first. We work backwards from that. You take the high road because there's less traffic. And if you really needed to sort of summarize this whole process, you just want to detach with dignity, right? Like it is a detachment, absolutely is a detachment. That doesn't mean that you're not still connected because most of the time you will be because you have the special needs child. I mean, some people just completely exit the process and they stop being a parent effectively. And you know, those cases, those are heartbreaking to see, you know. I mean, and those have their own challenges, right? When one caregiver is 100% caregiving, you know, I mean, that's sort of a different circumstance. But most of the time you're going to have someone who's at least going to ostensibly try and be involved in decision making and what have you. And just remember that if somebody, divorce coach, mental health professional, I don't care who it is. If they tell you to communicate in a way that's not Biff, then you need to really reevaluate whether or not you need that person on your team. And I'll just leave it at that.
Right, definitely BIF is
Yeah,
something
good
to be
call.
thought about, and then not just after divorce, as you mentioned, but also during divorce, leading up to um, coming to agreements, because you're going to find that that's going to help diffuse maybe some of the tension and conflict that potentially could exist or already exist by using certain ways to share information and share your thoughts and try to come to agreements, whether it's on divorce or post divorce as well.
Yeah,
So
that's
you
right.
guys, oh,
And the only other thing I'll say is that certain things can be modified. I mean, the one thing that really cannot be modified is the settlement of the community estate. Okay. So, like, if you're going into mediation, don't think, well, I'll sign this, and if I get buyer's remorse, if I don't think it's a good deal, I'll just not do it. Like that's not the way that works. Like mediated settlement agreements by statute are supposed to be irrevocable, and it is extraordinarily hard, not impossible. I've done it a couple of times, but it don't count on it. Like, absolutely do not count on it. When you're getting ready for mediation, you need to go in with the mindset that if I'm going to sign a deal, this is the deal. And there's no backsies, there's no maybe horse trading for something later on down the road. Don't go in with that mentality because that will set you up for disappointment.
For sure. Yeah, and I know we're
so
running low on time, and I know we want to answer some questions. So let me just go
Yeah.
through.
right. Yeah, I
Yeah,
would
let's go
love to
some
get to some of
questions.
these questions. I'm interested in how I'm reading here from the chat. I'm interested in how to maintain guardianship of a disabled adult child when divorcing.
I think the
Can you
first
guys
question you have to ask yourself is where is the guardianship and where is the divorce? And this is one of those areas where what part of the state you're in really matters. So, for example, if you're in Travis County, there's a probate judge by the name of Guy Herman, and I've consulted on cases in Travis County, and I've had cases in Travis County, and the thing about Guy Herman is he's a probate judge, but he wants to hear everything. He was taken up all the way to the Texas Supreme Court about whether or not he could grant a divorce as a guardianship judge, and he can't. And so, but if you're in Harris County, which is where Houston is, those probate judges they're probate judges and not family court judges for a reason. They don't want to resolve family court matters. They want to resolve probate court matters. And so they're going to defer as much as they can to the family court judge. So a lot of that is, the other thing too is like just be prepared regardless of what part of the state you're in. If there's not an agreement to be co-guardians, I would be shocked if a probate judge appointed divorced parents as co-guardians if there was a history of conflict, because that just seems like a recipe for disaster. I mean, look, I'm primarily a divorce lawyer, so I mean, maybe I would be proven wrong, but just intuitively, I would be surprised by that.
The next question, what is your experience with indefinite child support for an adult disabled child when the divorce happens after the 18th birthday has already passed? Do you have guidance or suggestions on that?
Right. So, a couple of thoughts. First of all, one of the primary inquiries is always the best interest of the child. Okay. Second of all, and this is actually one of the differences between like family support in a probate proceeding and child support, right? Because child support by statute is driven by needs, not so much lifestyle issues, right? Probate court, sometimes they're more open to it. Like I remember years ago, I went to a presentation and this guardianship attorney was talking about how she got the probate court to approve equine therapy. Um, it would be hard to get that in family court. I'm not going to lie, unless you had someone showing the proven need. I think each case is different. I think if the child was young enough in the underlying divorce, then you would probably have a good argument for seeking indefinite support after the divorce, right? But each case is I hate to give sort of the cliche lawyered answer, but I will. It depends.
Right.
Yeah,
So in the circumstance, I'm not sure this is what the question is asking, but is if you're getting divorced and your child's already over 18, then can you still get the lifelong indefinite
Yes.
child support?
Yes. If it hasn't been resolved in a prior proceeding, I mean, you're not, the law doesn't expect you to go after your current spouse for child support. Right. I mean, theoretically you could, but the law doesn't expect that. The divorce basically abates those types of claims. So yes, you can absolutely get indefinite support for a child older than 18 if this is the first time the child's interests have been litigated. Absolutely.
Now, what about, do you have any experience with the conflict between the rights and duties as listed in the family code versus the rights and duties in the estate code for guardianship?
It's thorny. I moderated a judicial panel this summer that had a family court judge, a probate judge, and a probate litigator. For the Special Olympics Committee for the Houston Bar Association. And it's thorny, and there are no cases that have definitively resolved that issue. I don't know if that's changed since June. Off the top of my head, I haven't seen anything. And also I think at the end of the day, it depends on which part of the state you're in. Because like I said, you're in Travis County and you have something already in Guy Herman's court, just um, for better or for worse, you're going to have everything resolved in Guy Herman's court. If you're in Harris County, it's different. If you're in a place like Montgomery County, it's even more of a it depends kind of situation, unfortunately. But that's a very perceptive question because there are inherent differences, and the judicial panel I moderated in June. I mean that the family court judge, she had been an attorney general lifer. So she had only done sort of child support issues and she had done a lot of obscure child support issues. And then the probate judge has a reputation for being just a very learned person, right? And so before he
Mhm.
took the bench, he was the marital property reporter for the real estate section and the probate section of the state bar. And then he didn't want to do it anymore. And so I took over that role for him. But I can tell you that when he told me I don't think there's a clear answer, I'm like, I took that as gospel.
Yeah, not necessarily the end all be all, huh?
It just
So,
hasn't been decided. Yeah.
what about in situations where it's a high conflict situation? The non-custodial parent hasn't even met the child who is 6 years old, doesn't provide anything. Um, is there deviation from the standard boilerplate divorce scenario in cases like that?
There ought to be, but I can tell you, and I got this going on in a case right now, that the legislature was in session in 2025, okay? And so you have a bunch of laws that were passed. Some of them only apply to cases that were filed after September 1st, and some of them apply to cases that are pending on September 1st. So if they were filed, but they haven't been resolved yet. And there is something called a fit parent presumption. And even if your particular situation in life doesn't, like the statute doesn't explicitly link to the fit parent presumption, just know that if you're really trying to to deviate from sort of the fast thinking sort of standard operating procedure in family court, you need to rebut the fit parent presumption, and you need to do it with something beyond just your word. You need to have corroborating documents if you're going to rebut, because now you're expected in a lot of situations to rebut the fit parent presumption with what the law calls clear and convincing evidence. Okay, that is a higher burden than what you normally have in family court. Clear and convincing evidence is the same evidentiary threshold that you have to meet to terminate somebody's parental rights. The only standard that's really higher in the law is beyond a reasonable doubt, and that's used to convict somebody in criminal court. So you have the effectively the second highest evidentiary burden if you want to start rebutting the fit parent presumption, and just be prepared to do that early on in the litigation.
So one question that I have and that I get all the time that I would love for you guys to talk a little bit about is the child support beyond age 18 needs to go into a first party special needs trust so that the children don't lose those Medicaid benefits, SSI, things of that nature. How difficult is it to go back and set that up if someone didn't know about it? And how is it best to set up that ongoing child support and that first party special needs trust? When is the best time to set that up so that there's not an issue going forward?
No better time than the present. You need you need the trust drafted. It technically has to be court ordered, right? For it to be a true special needs trust under 154 of the Texas Family Code. So you'll need a court, and like, look, child support is one of those things that you really can't just have a side deal on. Like, you're gonna have to get a new court order, right? And people are like, oh, but we get along. I don't want to go to court. That'll be an emotional trigger. And I'm sympathetic to all that. I really am. But it would be irresponsible of me to suggest that you could just do a side deal like that. You need to have a competent estate planning lawyer in special needs estate planning, draft that trust and have it approved by the court and created, and then have the monies directed there. And depending upon where the obligor, which is what the law calls the person who has to pay the child support, depending upon where they work, there could be some nuances there as well. It's 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 hard. It's harder for children with special needs to be treated fairly in this system. It's unfortunate, but it is. It is the.
Yeah,
I feel it's the
absolutely.
case.
Absolutely. There's a question in the chat box that I can answer. My child is 27 and still getting child support into a first party CS trust, child support trust,
Hmm.
maybe. What happens when he dies? His health is poor. Well, what happens with a first party trust is generally that there's a Medicaid reimbursement clause written into this. Do either of you have history working with these first party trusts?
What I can say is that, like you said, there is a Medicaid payback provision as part of that. And so you don't want to look at that as like a savings account or to accumulate funds. You want to be able to use those funds. And I'm sorry that your child's in poor health, but we definitely want to use those funds on things that your child needs. And that is not the place to have like a money built up. Maybe you can do that maybe in a third party trust or other type of mechanisms, but definitely not in the third party trust. Oh, your ex-husband is.
Oh, and she says that her so okay, not the child, the ex-husband.
Yeah, thanks for
So
clarifying.
what happens when the ex-husband passes? Well, then child support stops, doesn't it?
No,
No.
it's an obligation of the estate. of the obligor. And so you'll need to go to probate court. And one of the interesting wrinkles there is that maybe not all the relief you could get. I mean, you'll have to get some relief in probate court. And this is going back to what I just said about how the legislature could have done a better job of taking into account special needs kids. So, like, if you have a neurotypical child, right, a child who's not disabled under the family code, then you know what their child support obligation is going to be because you're going to accelerate that to when they would turn 18 and graduate from high school, right? And so you can basically, like if someone defaults on a loan or a mortgage, right? They accelerate the mortgage and all the principals do, right? Same sort of deal in probate court with child support. The problem is that if you have an indefinite child support obligation, you don't know what the amount of the acceleration is going to be. And this was one of the questions that was addressed in the judicial panel this summer. And again, there really just weren't great answers. And then to add another wrinkle to it, you know, one of the differences between probate court and family court is that family court addresses all assets, right? Community property, separate property. Probate court doesn't, they deal with quote unquote probate assets. All right. They don't deal with, say, 401ks. That is a non-probate account. That is governed by a law called ERISA and now the Secure Act, right? And so for the first time, you can have a special needs trust funded by a 401k. Now, that would not be the jurisdiction of the probate court, I don't believe. That would be the jurisdiction of the family court. In addition to that, you would have to have judgments issued by the family court to garnish the 401k effectively by having it go into a trust, which I always thought you should have been able to do. Texas Supreme Court came out with a decision that kind of undercut that argument. But the good news is the legislature fixed that in 2021. And so you absolutely now can garnish a 401k for a child support arrearage. And you arguably can, even if there isn't an arrearage, although I suppose that's maybe not as clear cut. But you would need to go to family court. You probably still have to go to probate court for some of the things, and you're going to have to sue the estate, right? So you bring the estate in the family court. So whoever is the executor of the husband who's passed away, that person would need to become involved in the family court litigation.
Fantastic. Thank you so much, both of you. Karen is also asking, how do we calculate funding the trust? That's something that Consolidated Planning Group helps families with every single day, Karen. We could definitely calculate that for you if you plan with us um, to help you determine how much money needs to be in the special needs trust so that once you pass away, your child will be taken care of. I want to thank you both, Mike and Marianne, so much for being here with us today. I've kind of just flipped through the last of my slides, but I do want to point out that at Consolidated Planning Group, we offer a completely free initial consultation. We are able and willing to answer any questions that we can. And then we learn a little bit about you and your family and give you some advice based on what we see. And then we can talk about how we can help you and what our fees and planning process looks like. So please go ahead and schedule your free Zoom consultation. Follow us on our social medias. Also, you've got the contact info for Marianne and Mike Day, and you're going to be able to reach out to them later on with questions as well. So one last question, and then we're going to have to go, but it says, Karen is saying, so do I have to sue my own kids? And who are the executor? That sounds awful. So do people have to sue their own kids if they're the executors of the trust or the estate? Mike?
Well, maybe he looks like he might be frozen. So
Oh, man.
Okay.
Well, Karen, it looks like you might have to reach out to Mike separate from today's webinar. I'm sorry about that. He froze up or lost his internet connection. Um, but it is probably best for you to chat with him directly anyway. So everybody, I hope you have a fantastic weekend. Tomorrow's Friday, so enjoy the day and enjoy your weekend. And please do reach out to us if there's anything we can do to help. Thank you all for being here today. Thank you, Mary Ann. And I'll text Mike on the other side and let him know that we really appreciate the two of you being here with us today. Thank you, everybody.
Thanks so much.
Bye-bye.